So with the mechanics lien, you can actually sue the owner of the property. And so you got to make them understand that they really don't have a contractual claim against the owner of the property. And so if they go and sue somebody for breach of contract, they're not able to sue the owner. But under a mechanics lien, if they're foreclosing on a lien, they are essentially suing the owner. And sometimes they're suing people up the chain of command, depending where they are down the line. So they wouldn't be able to get any of those people up the chain of command if they weren't suing on a lien. So it's important to make sure that they understand that they wouldn't be able to do that otherwise, and that they can do it if they filed a valid lien. Also, a mechanics lien can prevent a property from being sold, transferred, or refinanced. Now, we all know that if they went and got a judgment against somebody for a breach of contract, that they could go file an abstract and do the same thing. But in my state, in Texas, for instance, I mean, that's at least a year before they get that far down the road. Those people have already sold the property and are long gone by that point. So it's important that if we can file a lien to hold up the property, that we do. And so you need to explain to them that the property being held up during that time, there's a good chance they might be paid either in the middle of the process of filing a suit and having it heard, or at least that the property will be there during that process and after. Another point would be that a mechanics lien can survive bankruptcy in some circumstances. I have seen this happen. I'm not a bankruptcy lawyer, so I'm probably not really a great person to explain to you how it happens, but I do know that since the lien is tied to the property and not the person, it's not like a lawsuit or a judgment, and oftentimes they've had to come to me to try to clear the lien after a bankruptcy. So we have gotten money after a bankruptcy from, for instance, a bank who has taken the property back from a bankruptcy. It does happen. I've had it happen on numerous occasions. I'm not going to say that we get as much money as we should have on the top end, but we certainly got some money, which was better than nothing. There's a lot of companies that are filing their own liens, and I'm sure you will figure this out, but you need to learn to convince your client that they should not be drafting these liens. And it's your job to convince them that it's easy to get something wrong. And there's not an exact formula that they can use, and there's not one form that they can pull off the internet. They're going to be able to get it correct. There's a variety of circumstances that makes filing these liens very difficult. So what I like to do is try to provide something to my clients to show them that here's the reasons why you can get it wrong, and is it worth it, and make them try to understand, okay, if it's under $2,000, maybe it's worth it, go ahead. But if it's over $5,000, it's never going to be worth it, and we should hire an attorney to do it. And you can come up with your own numbers with your client on that, but most of my clients do have numbers in their systems as to what they're going to hire an attorney on for these liens. So the top reasons clients get it wrong: they miss key components required by property codes. In your state, the property codes are going to have some kind of requirements of language that is required in either the property code or in the notice letters. And it's not just, oh, we send the lien out or we send the notice letter out. Texas, for instance, has a very specific requirement for the notice letters under residential and then the notice letters under commercial. And it's, a quote that we have to put in there. And so almost always when clients end up doing their own notice letters, they don't do that correctly. They don't put it in there. So right off the bat, they've done it wrong, and I don't even have to go further in reviewing what they've done because I can tell them that their lien is invalid because they didn't put the correct language within the notice letter. Another thing is they put it or send it to the wrong owner or GC, or they use the wrong name, partial name, wrong address. A lot of times when they fill out their contracts or get their information, they, say ABC contractors, and that's all they have. Well, the real owner is ABC General Contractors, Inc. And that doesn't sound like a lot of a difference to them, but it has a big difference to us as to liability and, formalities and that kind of thing. So when someone comes to try to have a lien removed, they're going to say, well, we never got notice, and we being the ABC General Contractors, Inc. And so that is a very valid reason to try to claim that you didn't get notice. And so I can tell you that most of my clients, they don't get the names right off the bat unless they somehow have a general contractor contract that has the full correct name. Also, they don't normally get the correct legal description. They normally do not know what the legal description is. Sometimes they go look it up on the internet and get it correct, but, a lot of times they do not have it correct. They calculate the deadlines wrong. You'll see later in our presentation that, some states' deadlines are from the beginning of the job. Some state deadlines are from when you start the work. Some state deadlines are from when you stop the work, the last time you did the work. Well, clients are confused. I mean, they've heard different things at different times from different people, and it's almost always wrong for their state. So they almost always calculate it wrong. And that, again, will make their their lien incorrect. They don't serve the correct people. A lot of times there are certain people that must be served, whether it be the general contractor, the owner, the person that they did the work under. All these people usually have to be served notice of this lien. A lot of times they won't serve everybody notice correctly. Or if they want to sue for foreclosure, they'll miss their statute of limitations. And we'll see a little bit later, but there is a deadline for statute of limitations on foreclosures that is different than a general breach of contract deadline. And clients generally will think it's the same deadline or of what they've heard before, and they almost always miss it.